again, recapping kind of where we left off. We will spend an hour until 11 o'clock on Chapter 111, but then I will switch to e-wills so we begin that discussion. On Chapter 111, we made the decision last week to abandon the representation provisions of Chapter 111 just because that was going to mire us down. And so, Lorianne, you have the, and I want to direct everybody to the version of Chapter 111. It's LC 210, date 9/14, and it's the clean version. So if you want to pull that up, Lorianne, I think I'll just ask you to walk us through that quickly, the parts that we are pretty well settled on, and get to the new areas that we need to discuss.
Okay. So last time we made it through quite a bit, but we skipped over, there were some, in the language that was provided to me by the group, there were some sections that seemed to be duplicative of ORS 111-215. So I went ahead and integrated those into 215. We punted on that to come back to this time. So let's go ahead and start with that. And that's section 12.
Lane, this is Jennifer. And
yeah.
I had a couple of small things in section 2. I don't know if you want to go through the beginning to end, or you want to go through the big picture like Lorianne's talking about.
We haven't spent a lot of time on these later sections. Let's go ahead and start at section 12, and then Jennifer, I'll rely on you to remind us to come back to that.
Okay.
Okay.
I also have it on my list to come back to. So,
yeah.
So what I did was basically just took those the sample language that was provided to me and just tried to integrate it with 111-215. So I think, has everybody had a chance to look at this? Did anybody have questions on it?
Questions, anybody?
Lorianne, this is Jennifer, and there were a few things from the old statute that I thought were good to include. It was old section 10, numbers 2, 3, and 4, and it was kind of about how you count the days of notice and all of that kind of thing, because those questions seem to come up a lot. It was on page 8 of that longer draft, the kind of messy draft.
Yeah, so let me see. So that would have been,
it was about computing.
Section, was that section FFF?
Yes.
Okay, so in my comments, so you should have another document that is outstanding questions, LC comments. There's a comment in there about why I didn't include that, and that's because that's already covered in orders 174-120, which, as far as I know, applies to probate proceedings. So we wouldn't put it in another section, because you could end up with conflicts if one's amended and the other's not. Is there a reason that 174-120 isn't sufficient to cover what you're trying to do?
Well, we were just trying to make it simple for people. Heather, isn't that what we were trying to do?
So we're drafting for the least common denominator. And I don't even know what 174-120 is.
Computation of time, right?
Yeah.
Right,
but applies to all the 174 is the chapter that includes provisions that apply just generally across the code for the most part.
Okay, sorry. Is the same provision in the UTCRs or the ORCPs?
I do not know the answer to that. Does anybody know the answer to that question?
Whitman?
Well, but I understand your point, Lori. There are lots of places we could put in computation of time if we wanted to be specific about it in the code. And you're concerned about putting it in too many places is, yeah, if it ever changes, then keeping track of amendments to that.
Well, that and the language that was proposed didn't differ from 174, 120. If it was
Yeah.
different, then that would make sense, but it doesn't really make sense to add it somewhere if it's the same.
Yeah.
And if you feel strong, we could include a cross-reference to 174, 120 that just says time is computed as provided in 174, 120. I mean,
So
With that, I'd rather do that, I think, than restate what 174, 120 says.
So the background on why Jennifer and I did that is because there's a conversation in civil practice about, for example, it would say on a final count 20 days. And is it 174? Is it, I'm trying to find it right now. There's a UTCR or a ORCP that adds 3 days anytime you mail.
that we have specifically carved out that doesn't apply to probate proceedings.
Okay.
In the whole ORCP thing that we've done.
Okay.
That's also something that I've addressed in here. That's section FFF sub 3. So in my notes to y'all, it was the group proposed including the exception to the 3-day rule in ORCP 10B. I left it out and instead I went into section 2B where we're talking about which ORCPs apply to probate proceedings, and I changed it from having the entire ORCP 10 applying to probate proceedings, and now it just says 10A, since we don't want 10B, which is dealing with that 3-day rule, to apply to probate proceedings.
I would love to see a cross-reference to 174, 120. And Susan, I'd love to see some legislative history just confirming that that 3-day rule doesn't apply. I recognize that I'm preaching to the choir, but it becomes an issue in civil practice.
I agree. I think anytime that we have other statutes that come into play, it's really confusing to anybody looking like, I'm supposed to know, I'm supposed to look over here for this. It's taken me 30 years to figure that out sometimes. And so I do think that that's a really important thing. If we have other statutes that have effect, we should reference them.
So Lorianne, we'll build a crosswalk to 174, 120.
Ooh, I like that. Build a crosswalk. Can I steal that one? That's really good.
It's a raised crosswalk even.
Footbridge.
Footbridge, there we go. Footbridge to 174, 120.
Did anybody else have comments on integration of the proposed language into 111, 215? Since it seems like maybe folks didn't track what I was doing as far as things that I'd left out and questions I had. One of the questions that I have is whether you want the new notice provisions to apply to wrongful death cases under 114.441 to 114.462. Because if we do, so these provisions we've said that these apply to chapters 111, 112, 113, 114, 115, 116, and 117. But the wrongful death provisions that were added to 114 recently weren't actually added to the chapter. They were just put in there. So say that something applies to a specific chapter, it doesn't actually apply to those wrongful death cases. So are you wanting this to apply, these new notice provisions to apply to wrongful death cases, or are we not dealing with that? Does that make sense?
Yeah, it does. Do we have any wrongful death experts on the call today?
I know more than I should.
All right.
You have to include the notice provisions. I have, whether or not people are properly noticed for approval of settlements in wrongful death cases and then in apportionment of wrongful death proceeds is what we call a fertile field for litigation. To the extent that you can clarify when notice is properly given and to whom it must be given, you got to do it. I actually just got distracted about 7 minutes ago on this call from an email on exactly that topic, where a wrongful death settlement is coming unraveled because somebody didn't give appropriate notice.
Well, and this is Jennifer, and I'm certainly not an expert on wrongful death, but I'm in the middle of doing one of these cases, and it was much easier if we just have the same rules for probate as we do
Yep.
for wrongful death.
Yeah, so the reference to 114 in the very beginning of section 12, you're saying, Lorian, would not pick up the wrongful death statutes because they weren't actually made part of chapter 114. They were just
Right.
inserted there.
Yeah, and I wasn't part of the drafting of that bill. Was anybody on this call part of that bill? Know why it wasn't added to Form 14?
And I think that was just an LC call. I don't think we made a determination about that.
What I can do is take a look through this, so the wrongful death series, and see if there's any reason that we wouldn't have included it. The problem is that I'll talk to Marisa. I'm pretty sure she's the one that drafted this, and see if there was a discussion. Because if we just add 114, the wrongful death section series to chapter 114, that adds everything that has to do with probate to it, which may not be the intention. But I just don't know enough about wrongful death cases off the top of my head to know how that plays. Is there, so Matt Whitman was saying that he's got some experience in this. Would you be interested in taking a look at the wrongful death series that's in 114 and letting me know if there's anything in the normal probate proceedings that should not apply to it? Does that make sense?
Yeah, we did break out wrongful death for, and that may be where Marisa came down, and I really don't recall the conversation about whether it would be made part of 114 or just kind of stuck there. But I think as a general rule, wrongful death would not be subject to all of the other provisions. We were pretty specific about what would apply to a wrongful death case. So I'm more inclined to, rather than make wrongful death part of 114 and thereby subject it to all of the other provisions that apply generally to the probate code, I think I'd be more inclined to add a reference to the wrongful death statutes in this section addressing notice.
Yeah, I can do that. So it'll read a notice required under OR's chapters 111 to 117, or, and then it'll cite to the wrongful death series. Okay.
Yeah. Anybody from last time around feel otherwise? I think we were pretty careful about addressing in the context of wrongful death what we wanted to apply to wrongful death, and it was not going to be the entire probate code.
And going backtracking a little bit to section 2 then, which is where we're talking about when the ORCP and Oregon Evidence Code apply. Same question there. Is that these new provisions about when to apply ORCP or not, do you want those to apply to the wrongful death proceedings as well? To wrongful death cases, or is that, are we intentionally carving out wrongful death from this discussion?
Well,
so real quick, I do see that at 114.444, which is the which is in the special wrongful death only probate section, it does provide that except as specifically provided, et cetera, chapters 111, 112, 113, et cetera, do apply. And so the default is whatever we do here is going to apply in these wrongful death probates. And I'm just whipping through it, and I don't see anything that would be contraindicated in making our notice provisions applicable in wrongful death as well.
You are right, and I overlooked that. So this whole discussion is an exercise in futility. So we don't need to talk about it. It's dealt with because Marisa is a brilliant drafter. Okay, so that takes care of that question. One other question I had was in the revised 111-215, we are removing the mandatory publication of notice if you can't find the person who's entitled to notice. My question for the group is whether we need to consider if this if this is going to have any due process problems. Because I know that there's quite a bit of case law out there about the sufficiency of notice with respect to the due process clause, and publication is a big part of that discussion.
So you were looking at what you did. It's on the top of page 9.
Yeah. So it used to be if you couldn't find the person, then you were required to publish notice that you would otherwise have provided to the person. And now it's just the court has discretion to allow you not to.
This is Judge Cobb. Doesn't that run afoul of that Supreme Court case that was requiring notice? The U.S. Supreme Court, I can't remember it now.
Also collection services.
Well, this is Jennifer. And Heather, when we drafted that, wasn't that based on the UPC or something that they had left out publication and included other ways of giving notice to somebody who couldn't be located?
Well, I think what we had talked about was that if everybody who's been on here forever remembers, we had a long conversation about publication toward the beginning of our committee process. And because I believe the UPC was talking about whether that was an effective way to actually reach creditors any longer. And Lane wisely told us if we tried to eliminate publication from the probate code, that we would have a lot of pushback from the Oregon Newspapers Association. And so I think it's a different world. I recognize that, Judge Cobb, that we have that case, but the basis of that case is you have to take reasonable action to give notice to creditors. And so if we apply that reasoning that we are attempting to take reasonable action to give notice to creditors, we have to think about who the heck reads the Kaiser Times? Nobody. I mean, in Marion County, the people who live in Kaiser who have kids who play sports, they read it. That's why I read it. I don't think that the Supreme Court case concerns are any longer addressed by the failure to publish notice. It's just not.
I would think that creditors specifically do read that.
Yeah, and I would
Simply-
say that people were probably as unlikely to read the Kaiser Times when that Supreme Court decision came down as they are now.
Yeah, but you have to remember which creditor. Yes, I agree that creditors like collection agencies are likely to look at the Newspaper Publishers Association, but creditors like that aren't in collection, I don't think they read those kinds of papers. Maybe I'm too forward thinking, but I find it hard to believe that Sears and Roebuck or Visa MasterCard reads those notices.
I don't think collection agencies read newspapers. I think collection agencies have OECI subscriptions.
Yeah.
Well, and this is really a different issue because we still have the publication of notice requirement, you know, at the beginning of the probate.
Right.
This is when we're trying to give notice to a party and we can't locate them. And in that case, it's usually an individual, you know, the long lost brother or whatever, and they're never going to read the newspaper in Kaiser Times or whatever. You know, you have a better chance of, you know, using an air search person or, you know, looking on Facebook or whatever. And so that really is, I think, the point that we were making is in this particular situation where it's a lost, probably family member, you know, publication is a complete waste of time and money.
Well, I mean, I think that's practically true. I'm not sure that a court would dismiss the due process issue with just an assumption that people aren't going to see the notice. I mean, we publish all sorts of notices in civil cases, foreclosure and summons, that we just the same, we really don't expect people to see. But I mean, it does seem to be kind of a basic due process requirement.
Well,
And
notice
I'm
the due
not
process
sure it would
requirement.
stand or fall just on an assumption whether or not people are going to see it.
Well, but I think what would have to happen, and I think the draft includes this, is you would have to tell the court, here are the efforts that we made to try to locate this person. You can't simply send the letter and have the letter come back and say, oh, I don't know where they are. You have to, reach out to family members, find out if anyone has any contact information, search on social media. And then at that point, depending on their rights in the estate, you would maybe have the ability to have the court say, okay, you don't have to give them notice. But I don't think it's just quite as simple as getting a return and not knowing where to look any further.
But Jennifer, then what are you going to ask the court to, what would be sufficient notice to protect the due process rights of that individual? Because you are coming to the court saying, nah, we can't find them. And in my experience, the search is not necessarily as exhaustive as you're suggesting. So then if there's not publication, what is a broad enough notice that the court would in fact order?
Well, that's a good question. And that kind of ties into another question I had about other parts of the notice statute, which allows notice to be accomplished by first-class mail to the person's last known place of residence, which that sort of gives me pause, because what if their last known place of residence was 5 years ago? And, that two families have lived there since then or something.
So do we leave publication in just as a pickup?
I think we do.
I think that's what the conclusion that we came to the last time.
Could I interject here? If you take it out, which I'm a big lover of publication, but you got to replace it with something.
Right.
And there's just nothing better. And its publication, with all its shortcomings, has always been recognized as giving effective notice to people, even though we all know it doesn't. So what other fiction are we going to substitute?
So for years, a lawyer in Salem named John Gear has been advocating that the state create a legal notice website. And that's gone nowhere. We don't have the funding to do that.
Yeah.
I think it's an excellent idea. I think it's probably a better effective way to reach people, but it's not happening. So that's what we've got is publication.
So let's restore publication. Where does that leave us then? So that will be E in this new draft, and it'll be publication. Where does that leave us with F? Is that an alternative to publication then? It's new language upon good cause shown, any other method determined. So is that alternative then to publication? If you've got, maybe that's what it is. I mean, we leave publication in as one of the bases of the provisions for notice. But if you've got a better idea that you think would, you can persuade the court would satisfy the due process requirement, then let's leave F in, and you can make your case to the court. Not publication, I've got something else. Do we want to do that?
I think that makes sense.
Okay. When I was running for the legislature, I used to fly a airplane with a banner behind it over parades in my district. So maybe something like that would be a reasonable method for notice.
So we're gonna go back to the default, if you can't find the person, is that you have to publish, and then we'll have this little exception, the court for good cause shown can possibly override that requirement.
Right.
But as far as the other changes that are in sub E there, So we're saying instead of the notice being published in the county where the hearing's to be held, we're changing that to where the probate court sits. Is the group okay with that? Does anybody have an objection to that? All right. And then we're changing the last publication. Instead of it being 10 days before the date set for hearing, it's going to be 15 days before the earlier of the date for the filing of objections to the petition or motion or the date set for hearing.
Yeah, that makes sense.
Okay.
Good. Okay, let's, does that take care of 12 then? Again, we'll come back and look at all these things one more, again, I shouldn't say one more time, but I want to make sure, I want to try and get through as much as we can here. So for today, anything else in 12?
I would suggest that folks take a look at the outstanding questions list, and I had 5 bullet points on there about requested changes that the group had proposed and why I didn't include those. Do you want me to go through those right now, or do you want to review those on your own?
Yeah, let's
go ahead,
I think, Lorianne, and try and go as far as we can on the walkthrough. And then in a next meeting or another meeting, let's go back through your list as just sort of a way to double check our work. Okay.
So let's go. Section 11 is 111-205. So Jennifer and Heather had comments to the proposed language that the group still needs to figure out how subsections 3 to 6 relate to the new ORCP section 2. Has anybody had a chance to do that? No.
Jennifer, Heather?
Who's on the call?
Jennifer and I are both here. Lorianne, could you tell me what the document name is and what page number we're on? I'm sorry, I was looking as you were talking and I can't find it quickly. Put my fingers on it.
Let's see. Sorry, I'm looking for. It should be called something to the effect of outstanding questions.
Okay. So I'm there.
If it helps, it's the last document that's attached to that group of documents that was sent on the 23rd at 2:50 p.m.
Yeah, I have that in front of me. I just didn't know which of the many.
Oh, we're on page 2.
Okay.
The bullet point, section 11.
Okay.
So let's perhaps, so let's read through what this does.
Yeah, that's what I'm looking
Yeah.
for. So
Yes.
now are we on ORS C 111 draft 91420?
Yeah.
Okay, that's what I was looking for. Now what page are we on?
Page
So
7?
section 7 or section 11 is on page 7. So subsection 1 says the probate proceedings commenced on the filing of a petition in a court with jurisdiction over proceedings. Petitions to commence probate proceedings are authorized under ORS chapters 113 and 117. So these are all, this is proposed language that the group gave me, and I did not make very many changes to this. So and then subsection 2, all petitions, motions, inventories in proceedings before probate court must be in writing and include a declaration under penalty of perjury in the form required by ORCP 1E. The declaration must be made by at least one of the persons making the pleading, or by the attorney for the person, or in the case of a business entity, by the authorized agent. A declarant who is physically outside the boundaries of the U.S. must make an unsworn declaration under ORS 194-800 to 194-835. Then the questions, the subsections that I had questions on are 3 to 6. And so, or that, sorry, that Heather and Jennifer had pointed out that the group needs to consider. So subsection 3 is ORCP 15A regarding the time for filing motions and pleadings does not apply. ORCP 15B, 15C, 15D regarding pleading after a motion responding to an amended pleading and enlargement of time apply. ORCP 17 applies except for attorney certification of inventories and accountings, and ORCP 19 does not apply to responsive pleadings. I'm wondering if it would make sense for our ORCP breakout group to take a look at these and get back to us at the next meeting with thoughts. So I think that was Matt Whitman, Matt Trump, and Brooks, who doesn't look to be on the call.
I'll go ahead and tell you that I think that the changes that we've already made to the section that, where Brooks and I laboriously went through every single ORCP, that those probably consume these sections 3 through 6. And I don't think that, I'll be happy to take some time offline to double check it, but I'm sure that we don't need 3 through 6.
Okay.
I think that Matt and Brooks and Jennifer and I already went through all of those. That was that
I think that's right.
head banging exercise that we had.
Request, if you would take some time after we get done with this and make sure that that works. And I just have a question about the drafting, I guess, Lorianne. For subsection 3, for instance, says 15A regarding time for filings does not apply to, do we need something there? To what?
Yeah, well, again, I used the language that the group provided on this, and I actually didn't think that that one was necessary at all because we've already said that ORCP doesn't apply unless you say it applies, and so go in and say it doesn't apply.
That's a good point.
I had other issues with that particular subsection, but. So subsection 7 on here, I actually pulled from the proposed language, section, the FXX, it's regarding the hearings. I felt that it just fit better down here than in a separate section. So actions in a probate proceeding are not triable by jury, except as otherwise provided by law. I did have a question about whether that's necessary. Is that necessary? But I don't really have a good reason not to include it.
I can talk that. The probate courts are courts of general jurisdiction, and they actually can, at least theoretically, hear matters that are triable by jury under the Constitution. Judge Tennyson always used to say, just because I don't see juries a lot doesn't mean I can't. So I think that to the extent that the court is hearing something that under the those many cases that discuss not abridging claims that are triable by jury at the time of the Oregon Constitution, that that you can demand a jury trial in certain cases.
Okay.
It never happens.
All right, so I'm gonna bounce back to.
Before we leave, I have a question on this section 11. I actually have 2 points. One is in paragraph 2, it says all petitions, motions, inventories, reports, objections, and accountings must be in writing and include a declaration under penalty of perjury. Does it make sense to require declaration under penalty of perjury on a motion or an objection?
Yes.
It does. Yeah, you do want people to be certifying that these things are, that what they're saying is in fact both true and supported by admissible evidence. But whether or not you want to we have another statute that talks about using the ORCP 1E declaration language. I mean, it's not that mandatory language that makes it a declaration. That mandatory language makes it an affirmation. I'll come back to this. I'll talk to you about this later, Laura.
Let me clarify, I guess. When we say include a declaration, are you envisioning a separate document that supports the motion, or are you envisioning that the motion itself needs to be signed under penalty of perjury?
Matt, this is Whitman. I think that what we're talking about is we're including the ORCP 1E language as a verification block. So, you know, an objection to a final accounting and petition for judgment of general distribution would say, I object, that proposed distribution doesn't track the will, and then, you know, the 1E language and the signature of the objector.
What if it's filed by the lawyer?
What's that?
Yeah, that's what I'm usually doing. I'm signing the motion or objection rather than my client. That's why I'm asking about this. I could certainly, if there was a need, it could be supported by a declaration of the person alleging the facts that are relevant that need to be sworn to. But I've not considered that to be the necessary step, because it seems to me that once you file that motion or objection, then the court sets a hearing, and it's that hearing where we're going to put in any sort of evidence.
So this is Judge Burton. Can I just chime in with one of my little pet peeves, and that is lawyers giving me declarations about things of which they have no personal knowledge. So I just, to the extent that some declaration or affirmation under oath is required, it needs to be from the client and not the lawyer, unless it's facts of which the lawyer has personal knowledge.
Well, that would complicate things.
But she makes a good point.
Well, that's true.
This is Brian, and I was just going to say, and that was always an issue for Judge Tennyson as well.
Yeah, and you don't want it to be going out and getting your client's signature on every motion. Well, yeah, on all the and every document basically that you file. So.
Well, this is Jennifer, and you know, now that we have DocuSign, it's way easier to get client signatures.
But is a DocuSign signature being considered valid now for court purposes?
Under the UTCRs, and I've had documents like that accepted in, I think, in more than one court.
Good to know.
Should I tell you about my case last week where a fraud was committed with DocuSign?
Yeah, I don't know. This may be going farther than we need to. For what's the policy purpose here?
So this is Lorianne. One thing to consider is we've said that ORCP 1E does not apply to probate proceedings. So if we don't specifically say when it does apply, then that whole requirement with the declarations and affidavits, would that be a problem? That's not applicable to probate proceedings anymore?
I think that is a question of what you asked earlier. How does this blend with Section 2 of our proposed legislation? And that was my second point. I think somebody probably does need to take a look at that. I actually I was not part of the group that came up with that list of ORCPs, but I see that section 2, paragraph 2 said, except as otherwise provided in, and had a list of statutes which included ORS 111-205, which is what we're looking at right now.
Mm-hmm.
So if here it said ORCP 1E applies, I guess, in the sense that it's being incorporated by saying that you have to have a declaration, then that seems to apply. But I think it would be better to put into section 2 of our bill more express language about how any of these ORCPs in 111-205 do or don't apply, and have them all in one spot.
Well, but let's talk about the policy. Do we want all petitions, motions, inventories, reports, objections, and accountings to be filed under a declaration?
And the rule right now, so if you look at the deleted language,
right.
That's the current language. Right now, it's petitions, reports, and accounts that require the declaration. So it's being expanded.
This is Jennifer, and I think we should have inventories included in that. You know, the purpose behind that, including that language, is to avoid having to have the client have a notarized signature. But I also think as important as an inventory is, and as an accounting is, that ought to be under penalty of perjury.
I'm fine with those two also. And in regards to petitions, you know, I think my kind of default is to think of the petition to probate, but
right.
There's actually a number of additional documents described in 111 through 116 that are petitions.
Well,
petition for final distribution. Say that again, Lane?
All petitions are already required to be filed under a declaration.
Okay.
Under current language. So what we're talking about is perhaps adding, I mean, we have petitions already, reports already, accounts already, or accountings as we've used here. And I think the suggestion is to add inventories and maybe not motions, which seems appropriate not to require a declaration for a motion. And then I guess objections.
Well, why do you actually, Lane? Why do you say that? Why do you say that motions shouldn't necessarily require a declaration? Because you know, out in civil litigation land, I mean, unless you are moving purely on a point of law, anytime you're moving on where there's a question of fact, you're going to include a declaration.
Well, yeah, and if nobody else wants to follow me up that hill, I mean, that's not one I'll die on. Do we leave this list then? All petitions, motions, inventories, reports, objections, and accountings?
I'm not trying to pick a fight about it. I'm just.
No. And I don't have a real good answer other than that. We're expanding the list, and I'm trying to figure out why.
But to clarify, Matt, you could, if you're filing a motion, the attorney may be signing that motion, but you're envisioning a supporting declaration that's filed with that motion. Is that right?
Matt, who are you directing the question to?
To you, Matt Whitman.
Oh, okay. Well, okay.
Matt
So,
Matt.
Sure. So let's be. So, for example, out in the real world, now that probate isn't the real world, if I file a motion to dismiss on grounds that something fails to state a claim, then I'm going to include a memo of law, and I'm not going to include any supporting declaration because it's not about a question of fact. I'm going to sign that, and I'm not going to sign that under an ORCP 1E verification. If I file a motion for summary judgment, ORCP 47 says that a party may move for summary judgment with or without supporting affidavits or declarations. And I can move for partial summary judgment on an issue of law, once again, with no supporting declaration, nothing for me to attest to that, what am I attesting to? That I should win the motion. So I think that the question is whether or not you want to require 1E verification. I'm not sure that you can parse it out finely enough to simply say that a motion must be, that some motions must be verified and some must not.
Right.
I think that I'd be in favor of leaving motions out. And if a motion is insufficient without a supporting declaration, then that's something to bring up in the context of litigation by the party defending against the motion. Sorry for rambling.
Okay, no. So we take motions out. And obviously you're right, if there's a statement, if there's a declaration in support of that, that's going to be under a penalty of perjury. But we leave inventories in, and I think that's fine because that's an assertion of important facts just in the content of the inventory itself. Reports and petitions and accounting's the same. In the spirit of taking motions out, I'd probably take objections out too. So we would include petitions, inventories, reports, and accountings. Should we go with that? Done.
Yeah.
All right.
Okay. Any other questions on section 11?
Yeah, I got one more. This is like really super important. In subsection 1, at the end of the first sentence, shouldn't that be jurisdiction over probate proceedings or the proceeding?
Well, I would think probate would probably be right there, wouldn't it, Lorianne?
Yeah, that works.
Good catch.
That was it. That was all. I had to contribute something.
Yeah. Right. Okay, let's go on.
All right, so let's go back to section 2. So on page 1, at the last meeting that we had, we talked about adding in the definition of probate proceeding into section 2. So that's what I've done. I put it in as a new subsection 1. So it's a probate proceeding means a proceeding under ORS chapters 111 to 117 for the administration of a decedent's estate. Probate proceeding does not include a proceeding for summary determination of a claim under 115.1451B or a declaratory judgment action under ORS chapter 28. Does anybody have objections to that language or suggestions for modifications?
Well, to me, it's just, I think it's just a style thing, but to me, I would make B part of A and just say it means a proceeding for the administration of the state, but not A and B. It seems kind of clunky to me to define it and then to say it doesn't include something in a separate section.
Well, it's our form and style, so I'm wanting to keep it that way. If there's no substantive reason for changing it.
So one thing that's occurred to me is if we're excluding summary determination of claim, would we also want to exclude summary review of administration of a small estate? Because those are similar proceedings.
It's actually, there's a distinction here. So because we're cross-referencing to the summary determination of a claim under 1B, that's the summary determination that's filed within the matter. But, or wait, am I getting that incorrect? If you look at the end of subsection, or of section 2, it's,
oh, I see. Right. You've got it down there and under, at the very end.
Right. Big A and big B.
Okay. Good.
Does that resolve your question?
Yes.
Okay.
I think that works.
Okay. One thing, when we met, we discussed clarifying the probate proceeding doesn't include civil commitments, name changes, protective proceedings. There was a whole long list of things that we were saying is handled in the probate courts, but we wanted to clarify that those specifically are not probate proceedings. And I left it out because the definition of probate proceeding that we used specifically references the probate code. So I don't think it's necessary to carve that out. I was thinking that maybe Susan could include that clarification in a comment to the draft instead. Is that okay?
Yeah, that works for me.
All right. And going on.
Can I make a comment here about 5A? You know, we're defining an issue in a probate proceeding as being contested if A makes sense, it's a proceeding for a declaratory judgment, including a will contest, but B is limited to the petition to remove a court-appointed fiduciaries. The response to the petition is not a contested issue. The debate about whether to remove all the pleadings that come in that proceeding are not contested issues. It's only the petition that is the contested issue.
Yeah, that's a good point.
And you have the same problem in D. You go to a proceeding, but then in E, I, you return to petitions again. So why are we limiting the contested issues to just the petitions? And it could be that, you know, if it is based upon a petition, that's fine, but the lead in 5A is if it is a petition. So,
that's a good question, Lorianne. Would proceeding be better in each of those cases?
We had a very long discussion about this in repeated meetings about how what we should call this. It started out, it was a contested proceeding. It was a contested matter. And what we landed on was a contested issue. And I mean,
no, it's not that. It's, yeah, I think to John's point is, if you look at 5A big B, it's describing a petition, and the petition, of course, is going to initiate a proceeding. And so I think John's point is, it's more than just the petition; it's everything else that would follow from that petition. So it's not the issue; it's what we're describing there.
So what would you call that portion of that follows a petition and all of the subsequent actions that are taken as a result of that petition without lumping the entire rest of the probate proceeding into it? How would you describe that?
A mini proceeding. Well, it's a proceeding that's based upon the petition, or it's initiated by the petition.
Okay, we can change that to.
The verb is the problem. It shouldn't be is. It should be something else, or it needs to be a different object. It's not. It has to not be limited to the petition. It has to be the petition. Everything follows it in any proceeding.
So
in sub A, we say a proceeding for declaratory judgment. It doesn't say a complaint for declaratory judgment. So in D, it's a proceeding to apportion, not a petition or motion to apportion. So it seems like.
What about arises out of a petition or arises from it? Does that work?
Yeah, because what we want to do is we want to encompass whatever follows from the filing of that document.
Okay, I'll change it to arises out of or arises from. I'll work with that on throughout that subsection.
But you also need to have arises in if you're going to keep sub A as a proceeding for declaratory judgment.
Well, I wasn't going to change the lead in. I was going to change each of the individual.
Yeah, I agree.
For the purpose,
it's fine.
An issue in a proceeding is contested if it is A, a proceeding for declaratory judgment, B, arises from a petition to remove the court-appointed fiduciary, C, arises from a petition or a motion for affirmative relief, D, a proceeding to apportion. Does that fit with what you're talking about, John?
Well, that's kind of redundant to have arises from 8 times. You make that more compact by putting it at the lead in.
I see.
And then we have to go in and change big A, big D, and.
Well, you got to change, and then you got to change an E. You got to change 1, 2, 3, 4, and 5 because the motion to increase the bond is just the motion. It's not the objection.
All right. Well, I think it's Lori. I think you get it. I think it's a style issue, really, as much as anything, to make sure that we're capturing not just the documents there that you're referring to, but what follows from those. Whether we call that a mini proceeding. And folks, on my computer, it says 11 o'clock. So I'm going to, faithful to our plan today, we'll end our discussion here, and we will come back. And pick up with this at our next meeting, but I do want to go ahead, faithful to our charge, and switch now to e-will, if there's no objection. And hearing none. So Susan, do you want to take it away on e-wills?
Sure, need to unmute. Yes, and I can't remember, and I didn't look back at notes to see how far we had gotten, but I think it wasn't very far, and I think
it was so long ago.
If I've forgotten.
Yeah, I think we need a reboot, to be honest.
I do too.
So as everyone else.
Yeah.
So Lorianne has put this in ORS language, which is great, because then we start with that rather than the Uniform Act, and she's taken the Uniform Act and put it there. So it's the 92320 draft e-wills that we'll be looking at, and you'll see in the comments some questions she raised, and then in some cases comments that I had to her questions, and then I have some more comments. So I think we'll just start at the beginning, given that we don't remember. Different is showing up red. I went back and looked at the uniform language, and that is the uniform language. So I think maybe we changed it and then it changed it back. I'm going to ignore that unless somebody has some reason, but don't worry about the different. I think it would make sense without it.
Excuse me, this is Judge Cobb, and I'd like to have a policy discussion if we're in agreement, because I don't, and correct me if I'm wrong, but I don't ever remember us having any kind of policy discussion about e-wills. The last thing I remember is, for those of you who have been on this committee, the never-ending committee, my recall is years ago we decided no e-wills, and I'd like to have a discussion about why this is necessary.
Judge
Sandy,
Cobb, we
This is
did have a policy discussion.
Judge Burton, and I also believe we need to have a discussion about why we would be doing this and whether we should be doing it before we have a discussion about how.
Sandy, help me remember the charge of the commission. I guess that may be the answer to the question why we would be looking at.
Yeah. So it's a good question for both judges. This was a separate project that was proposed. Professor Gary wrote the proposal and was approved for a work group by the Oregon Law Commission. There was a decision that was made between the chair and discussion with Lane and Susan that this would be the most appropriate group of people to discuss the eWills project. But this is considered a separate project, even though we have the same group, by the Oregon Law Commission. So just to be clear, that doesn't mean that anything would need to be necessarily passed, but the Law Commission would like this work group to at least discuss it. So I do think a policy discussion is appropriate, but that's where this project came from. It's not necessarily a direct connection to the probate modernization work group. It's just we decided as a commission that this group would be the best expertise, with the most expertise to work on this issue.
So this is Judge Burton. My issue isn't, is this the right committee? My issue is, I don't think we should start from the assumption that we're doing eWills and let's discuss how we're doing them. I think we first need to have a discussion about, do we want to do eWills?
So Judge Burton, this is Heather Gilmore. We did have a discussion about this at the initiation of this charge. And here's my recollection of the discussion. We hate eWills. We think that they're going to be fodder for litigation. But the reality that we're facing is that we already have the harmless error statute. And so they're going to be coming. And do we want to look at this eWills because they're going to be coming and because we have harmless error and have some format for our judges to make decisions? Or do we want to just do nothing at this time and wait until other states who adopt this legislation have some experience with it so we could make the legislation more appropriate? And the conversation was, at least we should be looking at the legislation so that we can have a more informed decision. We may look at this and decide at the end, we hate this even more than we thought and no way. Or we may look at this and say, we've got harmless error and it's going to be coming, so do we continue with it? That's my recollection of the policy decision we had within the last year. Is that everybody else's recollection?
Yeah, and also I guess I want to say too, again, this was in the sense that it was a directive of the commission to take up the eWills Act. I think it's fine. And I recognize that there is a high degree of skepticism among members of the committee, probably among all of us, including myself. But again, I was also skeptical about remote notarization when it came up as a topic. But I think we learned from the remote notarization work group that with technology, there are backstops and there are protections that make it feasible. I'm willing to be. I guess what I would suggest is that we suspend our disbelief for the purpose of working through this, and we may get to a point where we say, well, gosh, I'm surprised this works so well. I think I'm going to embrace this. We may not, but I think we owe it to the commission to make our way through it. And I will say that objections are duly noted and fully preserved going forward. But I think we owe it to the commission to make our way through the act. And then make a report back to the commission after we have considered the act.
And just one point as well is the commission did not put a timeline on this. It was more, it was approved. So I don't want anyone to feel like it's rushed. We wanted to begin the discussion because we've been discussing 111 for several months now, but I don't want anyone to think the commission gave a directive that it had to be done this session. Right. It was just that we should discuss it.
So this is Judge. Why have we jumped the line with this and not finish our original charge of Chapter 111, which I believe we want to have introduced in the legislative session?
Well, I guess that was on me in part. I thought it would be good for us to clear our brains of 111 to think about something else. And, you know, I think this group is capable of some multitasking. I'd like to spend, now we're down to 53 minutes on this and see where we go. And we may decide that we're just going to park it. But I would like to at least spend some time. To be honest, it would be a nice break from 111 to look at this. And I'm interested to know what the work group thinks about it.
Lane, could I comment on that?
Yeah.
Can I, you know, I'm skeptical about this too. I think you're going to get a lot of garbage with it, but still, I think about the Castro case, which I think I've got the name right. That was the one where the guy was dying in the hospital, and they did the wills on an iPad, and they had witnesses, and they did, you know, they did all that. And you know, in that case, the fellow Castro died right after that, and I think to tell his family that everything they did was ineffective is really kind of fitting into the category of the law is an ass. You know, it's the facts of that case are compelling, and we eliminated. You know, we wrote the harmless error statute, so it eliminated any application to anything electronic. It needed to be a, you know, tangible writing. So we didn't allow harmless error to be a tool that somebody could use to validate something like the Castro case. So I think the world is demanding it, and it's a good idea to do the effort to consider it and to try to build a system where it's going to, you know, work better than it might otherwise.
So this is Judge Burton. Can I just say two things really briefly? Lane, at whatever point it is appropriate, I do want an opportunity to just say, I don't think we should do this bill, as opposed to, I think this sentence in subsection whatever. So whenever that's appropriate.
No, well,
as far as I'll just say the comment about the harmless error statute, news to me that it doesn't apply to electronic stuff, because I've been admitting emails and all kinds of stuff under harmless error. So maybe that is something that we need to look at, because a big part of my question as to why are we doing this is that we do have harmless error.
Well, that's interesting. Thanks, Judge. Susan, you and John and I think we're on the CLE program a year or so ago, and I think I suggested that harmless error didn't apply to electronic, and I think you were of the opinion that it might.
I thought it does, and I know it's been used. It was used in Michigan to validate an electronic will. So I think it does. I don't think we changed. I
think what we say is it has to be written. I don't think we didn't specify the medium.
Right, right. And I'll add just two things from the drafting committee of the Uniform Act. The first is that the entire drafting committee didn't want to be there, just as in this committee. Everyone was skeptical, but it's coming. Whether we want it to come or not, it's coming. And we can use harmless error and have a process that requires a court determination. But the hope is with this act that there will be at least some smooth process that will make things a bit easier, so that not everything has to be litigated. The second thing is that if we don't do something, and this was a big part of the Uniform Law Commission's decision to create a Uniform Act, some of the business groups, willing.com in particular, they've created their own acts, and they have gone into states, and if we don't do something, they may show up here and approach a legislator. They may not come through the commission and hear all of our great comments, and try to get something passed, and they've done that in other states. So that was what we were trying to do. We were trying to get ahead of that. So we can conclude at the end of this, we don't want to do this. That doesn't mean it's going to go away forever. So with that, shall we at least use the time we have to go?
Let's do, and I will say again that all objections are duly noted and preserved for the record.
So back to the language, and this is something I would like help with, and maybe particularly from Lori Ann, but from the group. In the definitions, there's a definition of record. Record is a Uniform Law Commission term that is used to, instead of writing to mean what it says here, the information that is described. I'm working on another work group where that Uniform Act also uses the term record, and legislative counsel for that work group said record is not an ORS kind of thing, and was suggesting using writing instead. Record is used in uniform law land to have a bit of a broader definition, but that's something we should think about. And Lorianne has raised it here as well. Consider conflict with definition of writing. It may be more appropriate for the Oregon statutes to use the term writing rather than record.
I guess if we were to do that, I would want to make sure we go through our other uniform acts, because I know that record is pervasive,
right,
in the uniform acts. And you know, I don't have a strong feeling one way or the other, but we would want to make sure that all of our uniform acts use consistent terminology then.
Right. So that I think we can hold off on. Maybe I'll talk to Lorianne separately. Will is just the cross reference, which makes sense. The other thing just about the way this is drafted, and Lorianne has already fixed some of the places. This is drafted based on the Uniform Probate Code. Our statutes are not hugely dissimilar, but they are different. And so some places, for example, this definition of will, it makes sense to kind of tie it to our statutes. So we've done that. Questions about definitions? It's more interesting if we get a little farther.
Yeah, let's go ahead.
Section 4, I just want to mention the purpose for that. This says an electronic will is a will for all purposes of the law of this state. The law of the state applicable to wills and principles of equity apply to an electronic will except as modified. The purpose of that is the rest of the statute doesn't provide requirements, for example, about capacity or undue influence or the age requirement for a testator. All of the other rules that apply to wills apply. And so this act only adds rules that are specific to electronic wills. And I know I got a question from folks in Washington State who said, well, why don't we have a requirement that the testator intend that the document be the will, as we do for harmless error. And the reason is that that's part of the common law. A document is a will if the testator intends that the document be a will. It's not in our will statute, and so it's not here. So all of that other law comes in, and if you see something missing, it's probably not necessary if it is in some other place in the law. Section 5, choice of law regarding execution, is a bit of a challenge because it will execute electronically. We have to figure out where that is. If I'm on my computer in Oregon and my witnesses are up in Washington and the notary is over in Idaho, if we're on the same room, we know where it's executed. If we're not in the same room, it's challenging. So Nevada statute allows me in Oregon to zoom into Nevada and be treated as if I executed a will in Nevada, even though I'm not there at the time I'm executing it. I'm not a resident of Nevada. I have no connection with Nevada other than the fact that the company that operates in Nevada will allow me to do that. So the decision for our kind of default, the uniform law default, is that if the person is physically located where the testator, if the testator is physically located where the will is signed, that's okay. So if I go to Nevada and I sign a paper will today, it's valid if it's valid under Nevada law. And I can do that even though I'm domiciled in Oregon. So we kept that physical location, but otherwise it's the choice of law depends on where the testator is domiciled or residing when the will is signed or when the testator dies. So if I later move to Nevada it's okay. But I can't, Oregon law at least is not going to, or the uniform version, but if we adopted this, is not going to allow me as an Oregon domiciliary to execute a will in some other state and have that will be valid. Now, Nevada can allow me to have a valid will there and maybe probate it there, and that's up to them. But we didn't decide it as a default. We didn't want people using Oregon law to validate an electronic will if they either weren't physically located here or weren't domiciled or residing here. So that one is probably worth just checking in to see how, if we reach the right conclusion. And that's the rule in, there are 4 states so far with electronic will statutes. That's rule in 2, and I think 2 allow people who aren't physically located in the state to execute a will in that state.
Susan, can you remind us which 4 states have electronic wills?
Nevada was the first, and they have updated theirs to be closer to this. It's Nevada, Arizona, Indiana. That's me too quick. What's the 4th?
Somewhere in the southeast, isn't it?
Oh, Florida.
Yeah, that's what I thought, yeah.
Yeah, Florida was the one where willing.com made a big push and the estate planning bar pushed back, and now they have one. 2 of those states have a whole process that requires, in order for a will to be valid, that requires the will be basically kept by, the company does, I mean, the statute doesn't say it has to be maintained by a company, but basically it's somebody, it has to be maintained by somebody who is in the business of maintaining wills. And that's Florida, and it's either Nevada or Arizona that basically require a custodian that would be a company. The other 2 states don't. And it you know, changes what's valid and what's not. If it would be helpful too, I have written a law review article. It's not published yet, but Ripity is publishing it. And if that hasn't been circulated, I can get that to Sandy and circulate it. It talks about those 4 states and what they did and how they're different. I think there are other, I know Washington's working on it now, and we'll introduce a bill, and there are other states that are doing that. I think one state may have I think there may be a 5th state, because I think one state may have done something. May have that wrong.
My sense is that the concerns or objections to the e-wills is probably not dependent on the choice that we make here. I would say let's kind of continue our walk through, unless somebody wants to really dive into this. I'd kind of rather see the whole thing, how it works, and as a group get a sense of that.
That's a great idea. So
real quick, it appears Utah passed it.
That's right. That's the first one since we had the Uniform Act. So the execution requirements are set up to be as similar as possible to existing execution requirements. So signed by the testator or another individual in the testator's name, by the testator's direction, signed by at least 2 witnesses. And here's where we get the physical or electronic presence of the witnesses. It is possible, and I think some states will do this, to require that everybody be in the same room, the testator and the 2 witnesses and the notary all be in the same place. The way you see it written here, it's set up to allow for electronic presence of witnesses. In the current COVID conditions, that's really useful. The testator can be in one place and the witnesses can be in the electronic presence of the testator, and we have a definition of electronic presence. That's basically it. Let's see, the witnesses, the intent of the testator, I mentioned intent earlier. This is just saying that extrinsic evidence can be used to establish intent. The requirement of intent comes from other law. And we've removed Section 7, which is harmless error. That was in the Uniform Act because a state adopting this might not have harmless error. We already have it. So we will add electronic wills to that if it's not clear. I think it's already there. A big challenge with this is revocation, because an electronic will may reside on someone's computer. So the question is, how do we show revocation? Talked about requiring revocation by writing, but the problem is people are going to assume that they can revoke an electronic will by deleting the will, by going to the company if the will is stored on a company's website and the company says, delete here, deleting the will. There are various ways that people may think they can delete an electronic document and therefore revoke the will. So it says that the will can be revoked either by a subsequent will, which would be a writing, or by physical act. And then the question is, what does that mean? We had a lot of discussion about, smashing the hard drive or the thumb drive, sorry, not the hard drive, smashing the thumb drive. So here's where we ended up. A physical act established by by a preponderance of the evidence. So there's a question about level of evidence that was determined to be probably going to reach the right result in more cases. That the testator, with the intent of revoking the will, performed the act or directed another individual who performed the act in the testator's physical presence. So it's just some physical act with the intent to revoke the will. An intent has to be established. So that's pretty much what we have for physical revocation in our statutes for written wills. The comments say, so for example, if I send an email to somebody saying, my will is on your computer, please revoke it, that's not a physical act, even though I'm typing, which is physical, that's a writing. That would have to be, if I want that to count as a will, it would have to meet the will formalities or harmless error. And so that writing might be given effect, but it would be given effect as a will. If I hit a button that says revoke on a website that is connected with the service that's holding my will, that would be a physical act. And the comments do go through a fair number of examples of that sort, just to try to say what is meant. But the key here is the intent. So if the testator did something with the intent to revoke the will, it's revoked. If it's simply a lost will, if someone knows that the will existed in electronic form and it can't be found, then the lost will presumption will apply. If there are multiple copies, the other thing we struggled with is that with an electronic document, there are likely to be multiple copies. It's sufficient for the testator to revoke one copy. The testator doesn't have to go to every person that the will was sent to and revoke those copies. That revocation is the place that the Uniform Group drafting committee struggled with the most. But the other thing, while we still have time, I want to talk about the self-proving situation. Because this, when you look at the execution requirements, it's basically just what we have for paper wills. And I say paper wills, I know that wills can be written on tractor fenders and all that other stuff, but paper wills. We decided to permit a will to be valid without adding any kind of additional requirement. And we talked about adding some other additional requirement, and we decided we wanted the basic, this will is valid without more. But but to have the extra requirements be in connection with the self-proving affidavit. So if there is no self-proving affidavit, then whatever it is has to be proved by the court or in front of the court. And the self-proving affidavit is more difficult. So I want to look at that. So that's why there isn't an extra layer of requirement at the execution stage. And the reason for that is something like the Castro case, the case John mentioned, where it was actually a Samsung Galaxy tablet, not an iPad, where the testator signed, 2 witnesses signed. The issue actually before the court was whether that was a writing, whether it met the writing requirement, and the court concluded it did. So it was given effect. It was attested, it was a valid will as long as that counted as a writing, but it wasn't self-proved. There was no self-proving, and so it had to be proved in court. What we did with the self-proving affidavit is if everyone is in the same place, both witnesses and the notary and the testator are all in the same place, and we didn't, the definition for that is whatever the Oregon definition, whatever the state definition is for a paper will. Some states have different requirements about line of sight and what that presence means. But if everyone is in the same place when the will is executed, then the self-proving affidavit can be done by a notary electronically without using remote online notarization. It is possible to do an electronic notarization without this new fancy notarization. But we only want to allow that if everyone is in the same place. Or the notary could pull out a piece of paper and notarize it. Well, actually, I'm not sure that would work because the notarization has to be attached to the electronic document and be made part of that so that it's connected with that document. And if it's electronic, the notarization would have to be electronic. But we did provide that if somebody is not in the same place, one of the witnesses, both of the witnesses, somebody is not in the same room with the testator, then a self-proving affidavit could only be done using the remote online notarization technology, because the concern was that there were more possibilities for some kind of bad behavior, undue influence, fraud, something, if everybody wasn't in the same place. And so to protect against that, this remote online notarization process actually, based on what I've seen with the demonstration, provides better protection for the will than a paper will would have. And I was completely skeptical, like everybody else on this call, I'm sure. But we had a demonstration of how this works. With remote online notarization, there is a secure video link so everybody sees everybody. Okay, that's just the basics. But everybody whose signature is being notarized has to provide 2 forms of identification, show that to the notary. The entire process is videotaped by the notary and has to be maintained by the notary for a period of time. And then the document is locked. So that electronic document is locked in a way that any tampering would be, it's tamper evident, any tampering would be observed. Technology changes, probably somebody will figure out a way to hack it, but with current technology, it's better protected than a paper will in a drawer where somebody can substitute a page if they're really sneaky. So that's a good thing. That requires new legislation, which was adopted by the Oregon legislature, but just on a temporary basis because of the pandemic. It's going to be reconsidered next session. And if it's adopted, we will have that. It's being adopted rapidly across the country because it does provide a lot of protection. And I think I've lost track of the number of states that have it, but it is being adopted pretty rapidly. For the notaries, they have to go through an additional training and link with a service that helps with all the video stuff and that. So it's expensive for the notary, and therefore there's an additional cost involved for the testator, but it does provide a lot of protection. So Lorianne's notes note that she's taken it out for now because we have this temporary, the Uniform Act is called RELONA, so that's the easy way to talk about it. It's been taken out for now because we don't have it. The hope is that at the same, that RELONA will be enacted in 2021 on a permanent basis in Oregon. So by the time this would ever come to the legislature, it would either be enacted at the same time or have already been enacted.
Just a quick update: the probate the notarization work group is planning on moving forward with full adoption, and we're getting a lot of support. So the temporary adoption went well, and we don't think that's going to be an issue.
It's pretty impressive what they can do, and we can have the companies that support that actually it's organizations. Notarize is one of the organizations.
They're companies. Yeah.
They're companies. They are companies. Okay. They're very happy to come and do, little, I'm trying to say.
I will say, if this group wants to move forward and that is an issue, from the notarization group, we have a strong relationship with a couple of the companies, and they would absolutely be happy to do a full presentation if this group is interested.
That's what I was trying to say, a demonstration of the thing. So we can think about that. And then that's really it. So there are a couple more sections to look at, but that's basically it. The execution requirements are the same as those for a paper will. It's just being done electronically. The self-proving affidavit is where there is an additional requirement if somebody is remote, if not everybody is in the same place. So the other thing that's interesting about this structure is what's missing. There is no requirement of a custodian. Some of the states have a required custodian. The will is only valid if a custodian who is authorized under the statute keeps the will at all times, and there's a chain of kind of custodianship of that will. The reason the Uniform Drafting Committee didn't do that is that would then invalidate the Samsung Galaxy case, the Michigan case, where what happens sometimes is that people will write wills on their iPhones. They can be admitted under harmless error, which is what happened in Michigan, but they wouldn't be valid under a statute that had a custodian requirement. It raises a question of, how is somebody going to find the will after somebody dies? I think a lot of people using electronic wills will be doing them using a company to do that and having the company store the will, but not everybody will. So the Uniform Drafting Committee wanted to be broad and kind of include all the different types of electronic wills that are out there, and that's why that's missing. The certification of a paper copy is, at the time when you've got to do something in the court, how does that work? And that's what that is. I think I will be quiet now, Lane, and throw it back to you.
Lane, do you mind if I just add a few things about Rolona?
No, do.
Clarify. So it is temporary legislation. It is more expensive. A lot of practitioners are complaining about that because the notary has a maximum fee that they can charge of only $25. And in order to do remote notarization, you have to belong to one of the platforms, and the platforms aren't cheap. And so everybody's a little bit dissatisfied with that. They don't really understand what the platforms do and why the platforms are more expensive. There's an article coming out in the estate planning section newsletter and in the elder law section newsletter about Rolona. Jamie Weddle, who's from the Secretary of State's office, and I wrote the estate planning sections newsletter. So it has lots of comparisons. Remote online or remote notarized, which was Renee Hunter that Lane and Sandy, you might remember her. They offered to do a class that went out on the elder law and the estate planning listserv for free so people could learn about it. And that was on the 23rd of September. I was in court, and so I didn't have a chance to go, but I have emailed Renee, and I just did it yesterday and asked her, hey, how'd that class go? But there's lots of opportunities for people to learn about it. If we are doing remote online notarization and remote wills, well, I mean, it's going to be interesting what we decide to require in terms of record keeping of the witness ceremony. But It could be a positive, it could be a negative. As we all know, video comes off kind of funny. It could be showing someone have total capacity when they don't, and someone having lack of capacity when they do have capacity. So I just wanted to add what's going on with Rolona. I think it's a good thing. I think it's more expensive than people anticipated, but I like the idea of having a video record with a trained notary versus the 20-year-old clerk at the UPS store.
All right. So, Susan, we don't have the demonstration here. We don't have one of the companies that does these things, but walk us through how you've experienced through the work group a typical e-will execution. Just not the dramatic kind done on the cell phone on the beach or something like that, but the thoughtful e-will drafting and execution.
If the testator has used one, a company. Well, actually, let me use it as with the lawyer.
Okay.
So I could, because I think one of the reasons some lawyers have been concerned about this is that there are companies that allow people to pay $69, draft your will, and end up with something that's not really very good, but it will be a will. So that's one thing that's going on. But the sense that we got on our drafting committee is that lawyers would also be using this. So particularly, there were a couple of people we talked to who had a lot of clients who lived in remote areas. So a lawyer in Eugene has a client living up, I would say up the Mackenzie, but nobody's living up the Mackenzie, but someplace remote where person comes in for the consultation with the lawyer, they do all of that. They really don't want to drive back into town the second time. And so the lawyer drafts the will, and by email back and forth, or maybe a Zoom call, talks to the client, gets the will in final form. So the lawyer has the document in the electronic form, sends it to the client reads it carefully, yes, it's fine. So the lawyer is in the lawyer's office, and let's assume that the lawyer has become a notary under Rolona, if we have Rolona. The testator is at the testator's house. They have a secure video connection. And the witnesses could be the testator's neighbors who come over to the testator's house. They could be staff at the lawyer's office, or they could be the testator's friends next door on their own computer. So let's make it completely remote. Everybody's on a different computer, and they have to be, if we look back at our definition of electronic presence, they are in different locations, but they are communicating in real time. So not by email, but in real time, where it's as instantaneous as electronic communications are, to the same extent as if they were physically present in the same location. So let's assume that everybody's on something like Zoom, so everybody can see each other. The testator signs, the witness in there, let's see, I haven't done this actually, but the lawyer would put the document, do a share screen, and the signatures are all electronic, and the signatures are electronic. One of the cases that looked at this, somebody signed by typing the name, and our statutes already allow a signature by mark. So if the mark is entered with the intent that it be a signature. So the signature is added either by, I have my signature that I can copy paste, or by typing it in. I think there's a reference in our bill to the e-sign, and it would be that kind of thing. So we put in whatever counts as a signature. That's all happening remotely in all of these different places. That means that the witnesses don't see the entire, they see the document, and the testator says, I am signing my will. I want you to witness my signature That's what the witnesses are witnessing. They're not reading the document. They're not required to read paper documents either. New York, they had some temporary legislation just because of COVID, and they were requiring the document be actually transmitted, the entire document be transmitted to the witnesses. And the problem with that is that the witnesses normally don't get to read the entire will. And if my will is private, I may want somebody to sign it. I may not want them to read who I'm giving my property to. So they don't read it. Each person signs. And if this is being done under Relona, then the notarization process begins. Each of the people whose signature is being notarized show the 2 forms of identification to the notary. That's the part that's videotaped, and the notary then seals the document at that point, so it's kind of locked and becomes tamper evident for future. That's about the best I can do. It's yeah, I haven't seen one of these.
Okay. And then in
So,
terms of
say that see them sign it, is you hold it up and then type it in, or I don't understand how you say they see them sign it.
Yeah, I'm thinking. So it's on screen if they're typing. Yeah, and you can't see me typing. I could go like this and you can see me type. You're not going to see it. I think the document is shared and you're seeing the signature appear on the document.
So
I've been doing this with some of the remote online notarization, and you take turns screen sharing. So you would send document to signer A. Signer A would open the document on their computer, would then screen share so that all of us are seeing signer A on the document. Signer A would then go through all of the signature points and click sign, or type in their name or whatever that particular system has for signatures. Signer A would then have finished all of their signatures, close out of it. It then sends an email over to signer B. Signer B logs into the service, opens up the document, shares their screen to show us what's on their screen, does the same signing steps, closes it out. And once we've gotten through all of the non-notaries, it emails over to the notary. The notary logs in, opens the document in the service, screen shares, goes through, clicks their notary stamp in, and closes back out of it, at which point the document gets all of those happy encryption things attached to it, and its certificate that says that it's not being screwed with.
So is it like a split screen so that you can also see the testator and at the same time see the document that the testator is electronically signing?
It's just like a Zoom meeting where you've got somebody running a presentation. You've got the presentation on one side, you've got the people on the other.
Again, I'm happy to. I've seen the demonstration 3 times now, and I know that Renee would be happy to come on this group if we're interested. It's really one of these things that, and I know Heather's seen it as well. If you see it, it's a lot easier to understand.
Yeah, that would be useful, I think, just so. And I know that was useful in the Relona work group too, to kind of get a picture of how this works. Sandy, let's see if we can make that happen. Just
Definitely.
Again, this group can see what it looks like.
The other way, Lane, if I could just say, the other way you might have an electronic will is that I might have the will on my computer, and for some reason my printer's not working. I could invite 2 witnesses over. They could stand next to me, watch me type my name. I could turn over have them each type their names. That's not going to be self-proving using the Relona thing, but if I also bring in a notary, the notary could do the thing, but we're all in the same room. And so we all see each other that way. If anybody is remote, then the only way that it would be self-proving is through this process that we'll have demonstrated, because otherwise it is pretty hard to figure out how are people seeing what they're supposed to be seeing if you don't use Relona kind of stuff.
All right, let's open it up to comments, questions, and Judge Burton, Judge Cobb, I think your policy questions are fair game now. Sandy, I saw you posted on the chat Judge Donahue's questions.
Yeah, they were lengthy, and I can also send those out to the group, but I just wanted to have them available for people to look at.
So Susan, you're talking about that only self-proving if they go through the, if everyone's physically present in the same room, is that correct?
Well, it's physically present in the way that Oregon would require physical presence for paper wills. So the Oregon rules, and I'm actually not, because I teach nationally, and I'm not sure what Oregon, but if Oregon would allow somebody standing in the doorway, not actually in the room, whatever Oregon would allow for a paper will.
So the language in section 9 is what you're referring to, correct?
Let me look. Sounds like the right number.
Or are you talking about electronic presence?
Well, it's not clear to me what Susan was explaining is actually in this statute, because signed in the physical or electronic presence of the testator is up above, but section 9, it's the self-proving at time of execution. So I'm not understanding the language that she's referring to that would indicate if you're having a self-proving will and you're not all in the same room, you'd have to use the electronic, all the assurances from the electronic notarization.
It may be because, I'm not sure what Lorianne has taken out because we don't have Relona yet. Must be, it is section 9. It must be made before the officer.
Section 9 as written would seem to suggest that a remote notary situation would be perfectly fine for the required notary on this.
Yeah, I think, so I'm looking at Lorianne's comment. The electronic will is not self-proving unless the affidavit is completed at the time the will is executed. Well, that's a different question. I need to go back to the uniform version just a sec. The uniform version had a bunch of brackets to allow for states that didn't want anybody to be remote at all. Apparently Connecticut will not want to do that, we were told. Our chair was from Connecticut and she kept saying they won't ever do it. All right. So let's see what B1 is. I think, yeah, I think so. Section 8, Section 8 in the Uniform Act says that if I think it has to do with the bracketed language that was taken out, because Section 8B1 in the Uniform Act had language that says if, and this is the reference to Relona, and I think because we don't have Relona necessarily, it was taken out, but this is where it happens. So the way it would read is, if you look at B. Well, the numbering's different. The acknowledgement and affidavits must be made before an officer authorized to administer oaths Or if fewer than 2 attesting witnesses are physically present in the same location as the testator at the time of signing before an officer authorized under Relona.
Okay.
So it's set up to say any notary can do it, but if fewer than 2 attesting, because you can do an electronic notarization, apparently that's not this remote online notarization. But if not everybody, the testator and 2 witnesses, if they're all in the same room, then it can be notarized without Relona. But if anyone, one of the witnesses or both of the witnesses are not in the same room or same location is the language that statute uses, in the same location as the testator, then it has to be Relona or comparable provision. And that's what, if we have that, that's what we would put back in. But we would need to, if we don't have that and we want to say you can only do this if everybody's in the same room, then we would need to change the language. You're right, Judge Cobb. I think that got lost.
All right, I guess we have about 5 minutes left. I want to hear reactions to, and now that we've walked through this, and granted at a high level, but reactions generally to electronic wills.
This is Judge Burton. Can I get in for a couple of comments?
Yep.
So first I want to thank Jennifer Todd because I'm not on Zoom, I'm just on the phone. And so she's been back and forth with me a little bit about 112.235 and 112.238. Again, with credit to Jennifer's help, what we were, and this is the issue about whether harmless error applies to electronic wills. So we've got 112.235.4 that says a writing is not an electronic document. It says as used in this section. Then you've got 112.238 that just refers to a writing, does not expressly incorporate the definition of writing that's in 112.235. My thought was it would make sense that the legislature would not be adopting the definition of writing into 112.238 because it would make sense for them to want the additional protections of notice and so forth that exist in 112.238 for an electronic document and not to want an electronic document to be a conventional will. And then Jennifer Todd also points out that 112.235 subsection 1 says except as provided in 112.238. But anyway, all of that is a long-winded way of saying I have no problem with the harmless error statute. I have already, perhaps in error, but nobody has objected, admitted all kinds of electronic stuff under 112.238. And in general, I would be much more in favor of, if necessary, amending 112.238 to make it express that it applies to electronic documents than to create a whole new electronic will statute. Some of my concerns about the statute are, frankly, some of these definitions are incomprehensible. I mean, as a court to try and construe, adopt a tangible symbol or logically associate with the record an electronic symbol or process. I don't know what these things even mean. We've had some very nice descriptions of how things are going to be done, but none of those are actually required by the statute. So there may be e-will companies or e-notaries who have adopted some standard precautions, but those are not required by the statute. Ultimately, really my issue with this is the self-proving issue. I am fine with having e-wills with the safeguards of 112.238, which is the parties who presumptively would be interested get notice and an opportunity to object. And if there's something hinky about this electronic document, then it goes to the court to look at. If you have an electronic will that is self-proving, you have somebody appointed with no bond and they're off to the races before anybody can question what's going on, who had access to grandma's iPad, etc. And a lot of damage can be done. And furthermore, you're going to have them admitted in small estates where there's no oversight and no bond. And, you know, small estates may not seem like much, but to a lot of people, you know, that's all the money they've ever seen or are ever going to see in their lives. So that's my focus is I think we need the safeguards of notice and opportunity to object that exist in 112.238, and I'll shut up.
Okay, no, appreciate that. Anybody want to respond to that?
Well, I'll just respond to the incomprehensible language. It's tech speak. So that's part of the problem. The execute with a tangible symbol, that's easier because that could be a typed name, unless you're Prince and you have a symbol for your name. But mostly it's a typed name. The affix or logically associate is a term of art, and that's the notarization gets affixed to the electronic document, and they become electronic. They become associated together. They're kind of linked and then locked together. And that's a term of art. It's not defined. We talked about whether to define that further in the statute, and it's not defined because the technology keeps changing. And if we try to define a tech term, it's going to be obsolete in 10 years or 5 years or 1 year. So that was the problem with that.
All right, we are up to the hour. Here's what we'll do. I'll circle back, Sandy, with you and Susan. We'll talk about this.
Yeah.
At our next meeting, we will get back at chapter 111.
And we still need to schedule.
What's that?
We still need to schedule. I was just going to ask the group whether we thought we needed to do a 2-week again, or whether we want to go back to the month. 2? Okay.
Let's do 2.
All right, I'll get scheduling out this afternoon.
Okay. We'll go back to 111. We're making progress on that. So thanks for your work on that. And Judge Cobb, I think it was your comment about taking time on this. I certainly don't want to get diverted and lose our way on chapter 111. I think this was useful and kind of fun to think about. But I will circle back with Sandy and Susan, develop kind of a game plan for that going forward. For now, let's plan on chapter 111 at our next meeting. And Sandy, you will send an email, circulate an email for scheduling that, right?
Yep, this afternoon.
All right.
All right, thank you, everybody.
With that, I think we are adjourned for today. Have a good day.